First, thank you for tuning in. I'm Eli Suter with Suter Law Firm. I'm a virtual in-house counsel. I help business owners from entrepreneurs with startups all the way through to established business owners who are ready to start thinking about succession planning. I help them with a wide range of legal matters, many of which will be topics of videos such as this one. Here's what we're talking about today. But before we get into that, I do want to remind you that while I'm licensed in Arizona, New Jersey, and Pennsylvania, this information is not state specific. It's just general information, not legal advice, and you watching this video does not make you my client. Okay? Let's talk business law. In this lesson, we're going to be talking about your LLC, right? Here you are, you're my client, and you have all these questions. Starting with, how will my LLC be managed? Okay, I've heard member managed, I've heard manager managed. What do those terms mean? And finally, how will my LLC be taxed? So you know you want to form an LLC, now you have to figure out how you want to have it managed, right? You can be either member managed or manager managed. A member managed, any member can legally go out and bind the entity. They can sign contracts, they can borrow money, they can sell assets, provided it's not all or substantially all the assets. So they have a lot of power. Contrast that with a manager managed, where the members are not able to bind the company. Only a clearly designated manager has the authority to go out and sign contracts and do those things to bind the LLC contractually. You might be a member and a manager of the LLC, but if that's the case, you need to remember that there's no such thing as a managing member. You're either acting as a manager or you're acting as a member. Two distinctly different roles, like wearing two different hats, if you will. And as a manager, you may receive a salary, but how that is treated for tax purposes depends on how the LLC is taxed, which we're going to get into in just a minute. Depending on which state you're forming your LLC in is going to dictate how you establish whether you're member managed or manager managed. In Arizona, when you form an LLC, you file your articles of organization. Those are then readily accessible online. Anybody can go on and look and see if an Arizona LLC is manager managed or member managed. In other states, like New Jersey and Pennsylvania, when you file that formation documents, first of all, the terminology is different, right? It's a certificate of formation in New Jersey and a certificate of organization in Pennsylvania. Every state likes to call those formation documents something a little bit different, it seems like. But by default, those entities, you don't designate it on those forms. You can, but it's not a default question that's asked, whether it's member managed or manager managed. Like in Arizona, you have to pick one or the other. In New Jersey and Pennsylvania, you're member managed unless you have a written operating agreement that provides differently. Finally, I do want to touch on registered agents. In Arizona, they're called statutory agent. Again, it's terminology. A lot of people get confused. They see so-and-so is a registered agent. That must mean that they're a manager or an owner. That is not true. A registered agent has one role only, and that is to accept service of process, which is if the LLC is sued. They have absolutely nothing to do with the management. They are simply there to sign the service of process documents when the LLC is sued. So you've determined that you want to use an LLC for your business, and you've decided on your management structure. Now you have to start thinking about how you want your LLC to be taxed. Okay, interestingly enough, the IRS does not recognize the LLC as a taxable entity. You have, by default, if you're a single member LLC, by default the IRS, when you go to get your EIN, it'll walk you through this whole questionnaire, and at the end of the day, your entity will be disregarded for tax purposes, right? You're a disregarded entity. What does that mean? That means that you will be taxed as a sole proprietorship. You will report your profit and losses from your business on a Schedule C exactly you would if you did not have an LLC, if you didn't have a business entity, right? You still get the limited liability protection that comes with, for contracting with other third parties and whatnot, but for tax purposes, it is as though the LLC does not exist. Now granted, the IRS does allow you to check the box, it's called. So either a single member, or we'll talk about a multi-member, can elect to be taxed however it wants. It can be elect to be taxed as a corporation, whether a C or an S. I don't know why a single member would want to be elected to be taxed as a partnership, but typically that's not what you see. What you see is a single member LLC that elects to be a corporation and then taxed as an S Corp. And we'll talk about why you might want to do that. A multi-member LLC, by default, is going to be taxed as a partnership. Then you get a K1 from the entity, just as though you were in a partnership. For the IRS, it's exactly like being a partnership. You can have unequal allocations of profits and losses, which you can't have with a corporation, right? One owner could receive 100% of the profits or losses. Maybe you have a sweat equity owner and a money guy owner, right? The money person is putting in a lot of capital, the other one's putting in a lot of labor. Maybe the labor guy can't use all those losses, but the money person could, right? And so with a partnership, early on, you might want to be a partnership when you're not making a lot of money, because those startup losses could be allocated 100% to the person who could most use them to offset their, they have a lot more income, for instance. So also, in that instance, it's great to be a partnership. That unequal allocation of profits and losses makes sense and it's beneficial. However, with the new tax law that passed not too long ago, the new partnership audit rules have radically changed how partnerships are treated when it comes to being audited. A partnership is a pass-through entity. All the profits and losses pass through to the partners. And it used to be that if a partner underreported their income from a partnership or their profits, that the partner was liable. But with the new partnership audit rules, it shifts that burden to the partnership. The partnership can be on the hook for the underpayment, underreported profits, and that can be expensive. And that's even if the partner who underreported is no longer a no longer a partner, right? So let's say I'm a partner in a partnership in 2019. I sell my interest, and the partnership doesn't get audited until 2022. 3 years down the road, and they determine that I've underreported my profits, they can go back and go after the partnership, even though I haven't been a partner for 2 or 3 years or whatever it is. So it's important to have, again, we'll talk about operating agreements, but this is one reason why it's important to have a written operating agreement that deals with the tax treatment of the entity. So also with a LLC tax as a partnership, payments to the owners are guaranteed payments, and these are subject not only to income, but to payroll taxes. Payroll taxes are 15.3% for federal right off the top. That's your Social Security and FICA, and that's before you even talk about the income taxes. So if you make $100,000 net income, your guaranteed payments generally you're going to owe $15,300 on just in payroll taxes right off the top. Now, you're just like the single member LLC, a multi-member LLC can also elect to be taxed as a corporation, either a C Corp, which gets 1120, or this S Corp, which is 1120S. These are your tax forms. If you do this, there's no unequal allocation of profits, right? Only 1% owner gets 1% of the profits losses, period. There's no unequal allocation. But owners can get paid a salary for being an officer, in essence, or like the manager, and that salary is subject to payroll taxes. And on top of that, then they can also be paid dividends on, just like as if they own stock in a corporation, and those dividends aren't subject to payroll taxes. So go back to the instance where you have $100,000 of net income as a partnership, subject to guaranteed payments, where all that 100,000 is subject to payroll taxes, and 15,300. Let's just say, for the sake of math, that the owner paid himself a $10,000 salary, subject to the payroll taxes. That's only $1,530 in federal payroll taxes, and then paid the rest of it to himself as a stock dividend that would not be subject to payroll taxes. So that's a big difference between $15,300 in payroll taxes and $1,530. So there you go. Thanks again for tuning in. I hope you enjoyed that short video, or if you didn't enjoy it, you at least found it informative. My name is Eli Sluter. I'm a Sluter Law Firm. I'm a virtual in-house counsel mostly to business owners and real estate investors. I help with a wide range of business and contract matters, anything from non-disclosure agreements, independent contractor agreements, buying and selling businesses, things like that.
Estate planning, I can help anybody with estate planning, but it's especially important for business owners to have an estate plan in place early. Succession planning, that includes buy-sell provisions or buy-sell, standalone buy-sell agreements. Asset protection is something that applies to everything that I do. Real estate, anything real estate and related, whether it's residential, commercial, whether you're buying, selling, or leasing, and if you're leasing, whether you're a landlord or a tenant, I can help. Finally, trademarks. I want to make sure that the brand that you are putting all your blood, sweat, and tears into building is something that you can protect and that isn't infringing on somebody else's rights. Like with everything else that I preach, it is very important to remember that an ounce of prevention really is worth a ton of cure. Why do I preach that so much? Because I've seen the ton of cure too many times. So please give me a call sooner rather than later. I'm happy to help you. All right, thanks again.